All right, welcome future barristers. Today, we are going to break down one of the most persuasive and yet one of the most perilous forms of evidence you will ever have to deal with: eyewitness identification. Look, mastering this isn't just about getting through the bar exam. It's absolutely fundamental to your practice. And this isn't just some academic theory, you know? The stakes are unbelievably high. The courts themselves have said it over and over. This kind of evidence has this powerful, almost seductive effect on a jury. But its history is just littered with wrongful convictions. And that's exactly why the law has built this fortress of special rules around it.
So, the big question is, how does the law actually handle this mess? Well, the whole framework we're about to unpack is really a balancing act. It's designed to somehow harness the power of this evidence while shielding the court from its profound unreliability.
Okay, first things first, we have to get to the absolute heart of the problem, and it's this. This isn't about catching witnesses who are lying. No. It's about protecting against the witness who is 100% honest, 100% confident, and 100% wrong. So here's the crucial point, and you've got to remember this case for your exams. The High Court in Craig v. the King made it crystal clear that this is largely opinion evidence. It is not a statement of fact like, the car was red. It's an interpretation, and it's based on a very, very fallible human memory.
And just think about how many things can contaminate this so-called opinion. I mean, it could be a fleeting glance, terrible lighting, or just the incredible stress of the event itself. And then there's something called the displacement effect, where a witness's memory can actually be subconsciously overwritten by a photograph they're shown later on. As a barrister, every single one of these is a potential point of attack in your cross-examination.
Right, so to manage all this risk, the courts developed a primary safeguard. And that is the judicial warning to the jury. You can think of this as the law's main attempt to level the playing field. And this warning, it's not optional. It is absolutely mandatory. And this just brilliantly illustrates the core legal principle here. A witness's confidence in their identification has absolutely zero correlation with its accuracy. A super-confident witness can be just as mistaken as a hesitant one. And the jury has to be told this in no uncertain terms. Now, a proper judicial warning isn't just some vague, "oh, be careful" statement. No, it's a specific instruction. The judge has to direct the jury to become critical investigators of the evidence, asking these exact kinds of questions to really scrutinize the quality of that original observation. But the law doesn't just sit around and wait for the trial to sound the alarm bell. It imposes really strict procedural rules on the police right from the get-go. Think of this as quality control before the evidence even gets anywhere near a courtroom. Now, there are two main pretrial procedures. You've got the identification parade, the classic lineup, and on the other hand, you have the photo board. And let me tell you, the courts have a very clear preference. A parade is considered far superior because the witness sees the person in 3 dimensions, with all their posture, their movement, their subtle characteristics. A photo, that's just a flat, static image. The High Court, in the case of Pitkin, just brilliantly laid out the 2 major psychological traps of a photo board. First, the witness feels this pressure to pick someone, so they might just choose the person who looks most like their memory. And second, the very existence of a police photo can suggest a criminal history, and that creates prejudice before the trial has even begun. But look, regardless of which method is used, there is one word that governs the entire process: fairness. Fairness is the absolute non-negotiable standard for any pretrial identification procedure. Period. So what does unfair look like in practice? Well, the case of R.V. Blick is a perfect example. If the witness says the offender had a goatee and your client is the only person in the lineup with a goatee, well, that's not a test of memory. It's a complete farce. The procedure is fundamentally unfair. And this principle applies more broadly, too. Let's say the witness describes a tall, thin man, and the lineup consists of your client and 7 short, stocky men. The result is worthless, right? The other people in the lineup have to be sufficiently similar to the suspect to make it a genuine test of their memory. And please, I'm begging you, be deeply, deeply suspicious of the doc identification. This is where a witness, for the very first time, points to the accused sitting there in the dock and says, "That's him." It's incredibly prejudicial, and as the courts have said time and time again, it's usually of little to no evidentiary value.
Okay, next up, we've got a critical distinction you absolutely must nail down for your exams. It's the difference between identification and recognition. And trust me, the law treats them completely differently.
So here's the bottom line. Identification is what we've been talking about this whole time. A stranger picking out another stranger. That's opinion, and it requires all the warnings and procedures we just discussed. Recognition, on the other hand, is when a witness says they saw someone they already know really well, like a neighbor or a coworker. The law treats this as a statement of fact, just like any other observation, and those mandatory warnings might not even apply.
So, let's lock in the key takeaways from all of this. These are the absolute essentials not just for your exams, but for your entire future practice at the bar.
First, and please burn this into your memory, identification evidence is opinion, not fact. That is always your starting point.
Second, never ever forget that a witness's confidence does not equal reliability. It's going to be your job as counsel to challenge the jury's natural instinct to trust a confident witness, because that instinct can be dead wrong.
Third, procedure is everything. It is the only real quality control that exists in this space. If the police get it wrong, that evidence is tainted, and that gives you a powerful argument to have it thrown straight out of court.
And finally, number 4, always distinguish between identification, which is opinion, and recognition, which is treated as fact. Confusing the two is a critical error, both in an exam and, more importantly, in a real courtroom.
And we'll leave you with this thought. Your ability to really understand these rules and apply them, that's what stands between a client and a potential miscarriage of justice. Mastering this topic isn't just about passing an exam. It's about upholding the very integrity of the trial process itself.